hope you are well. It's 9 o'clock, the last Thursday, as always, of the month. We have our March webinar, our webinars about the market access in Germany, Austria, and Switzerland. And before we come to tonight's topic, live and let die or die hard, let me tell you some more words. We are Mars, the market access and pricing strategy consulting company here in Germany, based in Weil am Rhein. And we cover all the market access topics, inpatient and outpatients, for medical devices or drugs, and also digital devices here in Germany, Austria, and Switzerland. And what we do, we have a price and reimbursement strategy here in our value, and also we do all the health economics, and we do all the applications for the Austrian Hauptverband and also the Swiss BAG, and also all the other applications like the Diga application. And also what we do is we have here the market access, our Mars virtual reality preparation bootcamp. So what we also do, and that actually tonight's topic, we always also provide you with the best informations and the best support for a good price negotiation for your drugs in the AMNOG process or in the Diga applications, or in the other, or in all the other places where you need all the price negotiations. Yeah, so check out our Mars virtual reality bootcamp here. Yeah, and then also always the last Thursday of the month next, so you can actually register on LinkedIn already for our next webinar, where we go to Austria, where we have with our good friend Dr. Thorsten Peske here, where we talk about the pragmatic reimbursement pathways in Austria. So Austria, a little bit a small country, but also really important country when it comes to market access. And then in October, we have here the really important person from the Federal Joint Committee, Dr. Matthias Perlet, and there we have a really nice topic. We are talking about the experimental coverage in Germany, the good, the bad, the ugly, or the unknown. So really, it's a little bit complicated, so we want to really have a deeper insight with him there. And then in November, end of November, actually that's a little bit, it's not the last, Thursday of the month. It's the 18th, November 18th. So we are talking about regional drug budgets with our good friend, Dr. Matthias Flume from the KV Westfalen-Lippe. Yeah, and then when we come to the next slide, we also want to encourage you to ask questions. So after the presentation, we will have time also for your questions. You can use either the Zoom chat function here or the question answer function to raise your questions or comments. And the first question is actually, do you have a video, and how about the slides? Yeah, the slides are provided after the webinar, and also you can rewatch that webinar here on our webpage, which is www.marketaccess-pricingstrategy.de. And there you find all the last webinars, also with our good person, Dr. Professor Jürgen Wassem. Was a great webinar about the Mystic Arbitration Board. So, and that's also a topic which fits actually tonight with our good friend Bibiane Schulte-Bosse here, where it comes to price negotiations. So, yeah, and if you missed the webinar, you can actually subscribe to our YouTube channel. And now let me present our guest today. So we have Stefan here. Stefan, who worked for a long time at Roche and who's the founder of Mars, the Market Access and Pricing Strategy. Good evening, Stefan.
Good evening, Lutz. Good evening, Bibiane. Good evening, everybody.
And then we have also a good friend from the lawyer, from the Strata law firm, Bibiane Schulte-Bosse. Welcome to Düsseldorf. Hello, Bibiane.
Hello, everybody. It's an honor and a pleasure. Thank you. Good evening.
Yeah, and now we have a really nice talk as we want to have a question between, right, Roger Moore, Live and Let Die, and Bruce Willis, Die Hard or Die Harder. So tonight it's about the price negotiations in Germany. So which do you prefer, Stefan, Live or Let Die or Die Hard?
I mean, that's a good one. I mean, I have as well just had a quick chit chat with Bibiane before, and I think would be quite cool to go with Bruce Willis into a negotiation, even though that, you know, Live and Let Die, not a bad song, as well as something maybe to consider. But I think for negotiation, maybe, but just the young Bruce Willis probably would make it. So let's just see. And also, Bibiane, we'll see what you think about it later on as well.
I am Bruce Willis in the negotiations.
I can confirm that. Perfect. Okay, perfect. Thank you, Lutz, for the introduction. So before we come as well to Bibiane, Bruce, Schulte-Bosse, we obviously, first of all, again, quickly introduce, let's say, the overall kind of topic. I mean, today it's the price negotiation, which is obviously, and I think it's easiest if we just take that as a basis from the AMNOG process. Just keep in mind, and Lutz has as well just mentioned that, I mean, we have as well the Diga process, where also the price negotiations would be happening at the end, let's say after the evaluation process. And I think at the end of the day, I mean, Bibiane, we have as well seen already the frame of the negotiation, the framework, how it should look like. And I think it is very close to, I think, what we know as well from the AMNOG process. So I've also seen that a couple of persons from different Diga companies, I think, are as well tonight in the webinar. So just take that as well as a kind of approach, which I think will be very, very similar to what we know already now since many years from the AMNOG process. Very briefly, and again, you can as well just take that over from the AMNOG into the Diga. At the end of the day, it's important. The very first part is an evaluation. It's the clinical benefit evaluation. In this context, it's obviously done by the GBA. Lutz has well mentioned it already before. And in case the product would achieve an added benefit, that's at least the kind of normal rule. We all know as well that there are some exceptions where also products without an added benefit could obviously go into a price negotiation. Sometimes it's just because it's not the first indication. Sometimes it's also just a question to further, let's say, negotiate the prices even down, which is then obviously more in favor of the insurance side. But there are the different kind of added benefit ratings. Ultimately, I think what you can maybe keep in mind as well, and I think that's quite important, especially for the pharmaceutical area here now, is you need to open the door, and the door is opened if you have a positive added benefit. So if you don't get an overall no added benefit, then you're basically in. Important probably still, I would say, and we had a good webinar end of July with Professor Wagschall from the University of Freiburg, where we have as well discussed a bit about the potential implications from the elections, which we're looking forward end of next month. So currently it's still in the way that orphan drugs do automatically get an added benefit, a positive added benefit, and can obviously then directly after the benefit assessment by the GBA enter the price negotiation. So this is the kind of scene. If you have the Diga process, it's a bit easier, let's say, from the first part. So it's not really the question of an added benefit or not. It's rather the kind of point of view if you're basically going through the permanent registration with the BfArM, and then you're entering the price negotiation. So what is that price negotiation, right? I mean, we all know COVID has changed a lot. Yes, of course. I think when you look on the picture, this is just an example, an exemplarily chosen picture out of a negotiation room in Berlin. The negotiations have basically happened pre-COVID. I mean, we're as well just putting in there post-COVID. Let's just see. I mean, I still have some hopes that in autumn we might as well get at least some of the negotiations again back face-to-face in Berlin, but let's just see that. I think it's just important to also setting a bit the scene, right? How the whole kind of, let's say, endeavor really looks like. I think that's also a bit important if we discuss about live and let die or die hard, right? So first of all, it is basically in, or let's say with the GKV SV in Berlin. So there is a negotiation room where the two different parties obviously meet. And then there's also a preparation room. So you as a company would also have preparation room. Normally looks quite similar. And I think you would also get some snacks there. I think it's the most expensive snacks probably in Berlin, probably around Germany, but at least you get some snacks as well as some water and coffee, obviously. But jokes aside, I think currently, since the COVID-19 pandemic, we're obviously back to web conferences, negotiation. Team communication is obviously then a bit more difficult, quite clearly, but I think in the meantime, I think they are quite well known, and I think quite good, let's say, tools and let's say also tactics, I think, available through different messengers, or maybe even a separate kind of screen, again, that the team can at least see each other. Or sometimes it's also possible, especially now after the vaccinations which are available, that at least the team, the internal team, could basically meet up then and be in one room and just then have the negotiation with the statutory health insurance fund separately. So this is just very, let's say, broadly, obviously, just to see where this is basically looking for, or how it really looks like. It's very similar, again, I think, to the Diga. I think within the Diga, I think it's at least as well the kind of choices, right? Whether you have the face-to-face, if again it would be possible, and the web conferences. But at the end of the day, it is quite similar. So what is the structure? It's not what I think some of you might maybe know from other countries, where you basically have, let's say, a negotiation, sometimes even just in written, right? We know that, for example, as well from Switzerland, right? I mean, if you're maybe lucky or unlucky, that's your choice how you rate it. You could maybe do some telephone calls in Switzerland, but in Germany, it is, at least before COVID, right, it's face-to-face. Now it's just really clear, structured meetings scheduled for 4 hours. There are basically 4 meetings scheduled. You get the invitation directly together with your added benefit decision by the GBA, and that is then also you know, how the whole kind of structure is set. So you know, basically within, let's say for the next 6 months, where they said when those meetings are happening. Theoretically, you could also add 1 more meeting. I personally have not yet seen that really. Maybe Bibiane, you have seen one, but I think what is probably more common, and that is also what we see with the let's say, with the generally as well with the frame, that there are more kind of telecons as well aside, and further kind of discussions and communications. Okay, but I think moving even further, right, further into the kind of details here. I mean, you're setting the scene. Yes, it's Berlin and or virtual. And then we have the number of meetings. It's 4 hours. I think we also had clients where people were directly saying, why and what the hell are you doing 4 times 4 hours? That's by far too much, right? I just want to have that price. Let's just discuss about it. It's not exactly how it works, right? I think at the end of the day, it is as well a kind of quite, let's say, not only the frame how it works, but you need as well to go through the different kind of steps in here, right? The 4, let's say, negotiation days are structured. That the first one is probably more kind of welcome. Also, what you see here in there, you need to submit different appendices with European prices of your product. Then there's also the expected volume, the sales, what you need to as well submit, and obviously potential kind of cost of, let's call it, comparable drugs. I think also here, very important, keep in mind, you maybe know the appropriate comparative therapy from the GBA, which could be very similar, but I think sometimes we also have here already some fights, right, that the comparative, or the, let's say, the comparable drugs might not be even listed sometimes in the list of the GBA's appropriate comparator. So you have also already there some kind of, let's say, movement, and the first kind of, let's say, I don't want to say fights at the beginning, but at least, let's say, some kind of discussions, right, before you then also move further. And this is also an important aspect when we move over and discuss about the various aspects in the negotiations. Some further negotiation rules. I think there are some more as well in the framework, but the very first and important one is confidentiality. That's also where I think we need to see them, or let's say you need to as well understand that we cannot just show a lot of examples here as well with the product names quite clearly, but it's also within the negotiation that I think confidentiality is given. Very important as well, you as well, obviously, as the other side, has the right that whatever you think should be included in the official minutes. There are always minutes which need to be signed as well after each negotiation. They can and should be included. Obviously, keep thinking about it. We have also seen sometimes some mistakes, I would say always from the other side, right? Where sometimes information were included in the official minutes, where I think sometimes that was more already going to the kind of lockdown kind of area, where we just thought it would have been maybe easier for the negotiations not to include that directly in the official minutes, but it can as well be a quite interesting tool. Breaks sound so easy, but it's also very important to take the breaks when you think it's necessary, when it's needed. I think you can also use it strategically. I think there are different kind of aspects. I think it's also, and always obviously the kind of question, if you have maybe the better cards in your hand, right? If maybe the kind of momentum is with you, then you maybe want to go through the kind of negotiation, through that kind of momentum, or maybe it's the other way around. And then it's also the opportunity that you take a timeout, let's say, that you can as well come back into the preparation room, come back as a team, discuss what has happened, discuss next steps, etc., which is also important. And especially, I think that's one important component, the negotiation lead, when there's the face-to-face situation between the two negotiation leads, that this is then also, let's say, first of all, reported back to the team in the breakout rooms. And I think that's also something keeping in mind. What I mentioned as well beforehand, communication is happening, and especially happening obviously as well between the negotiation meetings, and especially when you see basically that let's say some discussions are maybe stuck, and or you need to find maybe somehow a solution for one or maybe more of the aspects. So it's not just those four negotiation days, but it's also some movement between, and sometimes, and I would even say a lot of times afterwards, right? I think Bibiane, I think that would be maybe as well interesting to hear further as well from you, but I think we have as well seen quite a lot of agreements, especially after the last negotiation day. Is sometimes as well, and obviously for companies not having a lot of experience, seeing that, you know, this is as well a bit of a push, right? You know, the end is coming, you need to agree now. So no worries. You as well sometime afterwards. So as one interesting kind of move. So drivers could be different ones. Quite clearly, you see that in the middle, the price is obviously in the middle, but there are a lot of different other things which also have an impact on the price. And we might as well hear from Bibiane some further aspects, obviously, which are then as well important from a contractor perspective. But you see here already European prices, the added benefit might play a role, not always, the time limitation, so-called mixed prices, right? Keep in mind, if you have different added benefits in different subgroups, for example, combination therapy, very important point, especially maybe in the oncology area. And not to forget, I think Lutz has mentioned that in the introduction, the arbitration board could also be sometimes a kind of trigger or kind of push against the other side if you think you might again have the better cards if you need to go to the arbitration board. So a lot of different things to handle. So you see already, it's not just the simple price. We go in there and discuss this. It's a lot more, and you could also influence, obviously, the price from a lot of more angles here as well. One of the opportunities as well is potentially, we just put a question mark as well after that kind of, let's say, sentence, right? Opportunity within the AMNOG for managed entry agreements. I would still say a question mark. Keep in mind, we have still more than 100 health insurance companies in Germany, and sometimes this is really difficult. I think with some of the new ATMPs, cell therapies, I think there was something as well created, but then not with the head association, but with the individual health insurance fund. So that's as well at least something to keep thinking about. And I think here also it's very important that to let's say try to fit that as well, obviously, to your environment and to your product. And I think we have had as well last year already a quite interesting webinar on that aspect as well. Price impact foreseeable. I think quite interestingly, I think there was already a paper in 2016 showing that, you know, the average kind of discount is somewhere around 20–25%, depending a bit on the target population, etc. And I think also when you see on the right-hand side, which was just published in the AMNOG report 2020, I think you would also more or less think around the 20%, that's the mean, right? But ultimately, you see also still some variation, and also ultimately, this is not just go in or, you know, offer 20% and you get it directly, right? This is always as well the question where you start from, what are your comparators, and also that you obviously pretty much prepared and have as well a good lawyer, obviously, as well on board, that you get as well the whole kind of package together with you in the negotiation. So having said that, I'm very happy, Bibiane, to have you today with us to also get the legal now impact. And please stay tuned. Bibiane is a great speaker, and she's making the legal part really lively. And I think that's also what I think we can all now look forward. Bibiane, the floor is yours.
Thank you so much, Stefan, and thank you for having me. Okay, I'm happy to talk to you tonight about the contractual parts and, of course, how do we get to the reimbursement amount. Next, please. How do I get to the reimbursement amount? As Stefan already explained, the legal framework for the reimbursement amount is key to each negotiation. The reimbursement amount, which is negotiated with the company, is based on the additional benefit decision of the GBA. A drug without an additional benefit should reimburse a reimbursement that is no higher than the annual therapy cost of the appropriate comparative therapy. And for a drug with an additional benefit, a surcharge on the annual therapy costs may be negotiated. So the basis of all negotiations, of course, as well as the other influencing variables, is the costs of the comparative therapy. And of course, the basis is the additional benefit of the drug. And this has recently been could you go the previous, please? Could you go back, please? Yes, this has previously been emphasized once again by the Regional Social Court of Berlin-Brandenburg in its ruling on teriflunomide, which I will discuss a little bit later. So in this current decision, the Regional Social Court even goes so far as to rank the decision of the GBIA in importance higher than the supporting reasons. According to the judges, the wording of the GBA decision takes precedence over any deviating statements in the supporting reasons. So this decision of the GBA and every word of this decision is now much more important and will become in the future negotiations. Next, please. So what else influences the reimbursement amount? Of course, as I said, the costs of the comparative therapy. And as Stefan already explained, also maybe the EU prices, the prices of comparative therapies and other aspects. And what you have to know is that there's no explicit weighting of these criteria in the framework agreement or in the law. So you could very much take in consideration additional criteria, and of course there's room to negotiate. Nevertheless, there's an overweight, what the courts say, to overweight the additional benefit in any case. Next, please. What I've always been asked and often asked is there any calculation algorithm for the reimbursement amount? The law says that the arbitration board decides on the basis of a free assessment of all circumstances of the individual case and has to take into account the special features of the respective therapeutic area. But just recently, the Federal Social Court decided on dimitro fumarat that the price ceiling in form of the costs of the comparative therapy is much more important than this assessment and circumstances that the law grants not only the arbitration board, but also the negotiation parties. The law says that the broad scope granted to the arbitration board by this sentence in the law is limited by the annual treatment costs of the comparator as a max price, as a lex specialis. And this, we only have a press release of this new decision, but this ruling and this decision of the Federal Social Court, I think, will influence the future price negotiations immensely. Next, please. The courts also say, and this is here a quote of the so-called mixed price decision on ibiglotide from 2018, the courts say there is no model and no concept to which the medical benefit of a healthcare service could be converted into costs. So everything is answered primarily to the negotiation procedure. Next, please. And the Federal Social Court also says that according to the legal materials, the decision of the arbitration board and also the decision of the negotiating parties is not predetermined by a concrete decision algorithm. So in the end, everything is free and the negotiation has a great importance in the whole process. Next, please. However, that the negotiation is of great importance. This recent decision on dimitro for marat, which I mentioned, is kind of, I think, taking this into question. Because it says that for drugs without an added benefit, it is not important if it's the most economical cheapest drug. The most economical drug is to take, but you can take the cheapest drug as a comparator, no matter what the market share of this drug is. And this is something I think that lowers the importance for drugs without additional benefit of the negotiations. We have to see where this leads in the future. Next, please. Which brings me now to the topic of the reimbursement amount agreement. The price negotiation and the reimbursement amount agreement comes at the end of the negotiation process, and it's the final point of each negotiation, this conclusion contract between the GKV and the pharmaceutical company. The contract is not trivial. It's quite short for Anglo-American understanding. It has only 8 to 9 paragraphs, but these paragraphs are kind of important and very interesting. For this reason, it's always advisable, as Stefan already said, to bring a lawyer to the negotiations, because there are always kind of other legal issues and questions that arise during the negotiations, in addition to the contract itself, and which the pharmaceutical company needs to address now. The GKV always uses its own contract model, so you're not free to with the wording of the contract, so you have to stick to this contract model they are suggesting. The pharmaceutical company gets a draft of the contract emailed in a synoptic form after the first negotiation date. This draft contract has 3 columns. On the left side, the suggestion of the GKV, and the middle column is for the suggestion of the pharmaceutical company, and on the very right side is then the consensus column. In the first negotiation date, there are deadlines agreed upon by which the pharmaceutical company has to enter its proposed changes in the middle company and send them back to the GKV. And then in the next negotiation date, you discuss this with the other side, the wishes of the pharmaceutical company, what they want to change in this contract model, and so on. Mostly it's like this, that the contract is discussed at least once during these 4 negotiation dates. You have at least once, maybe more, and the negotiation of the conditions will take place then often after the 4th negotiation date. Next, please. This is how a contract synopsis looks. So just you have an idea how this looks like. Next, please. No, you just missed one. Step back. Yes, thank you. Yeah, the contractual regulations relevant to the reimbursement amount. Of course, the contract has to talk about when you start the new reimbursement amount, so when it has to take place or takes place. Of course, the term of the contract and the conditions of the termination. Then the pharmaceutical entrepreneur has to decide whether he wants to replace the manufacturer discount, meaning including the manufacturer discount in the reimbursement amount. If he wants this, yes or no, it's something you can decide upon and of course agree upon with the GKV. Then you have to negotiate and decide upon in the contract of the reference value. Once for the price itself, mostly it's taking the milligram of the active substance, or if you take bottles or packages or something. And then you have to decide on the reference value for the quantities, because in the contract, and this is something which the framework agreement says, that you have to agree upon the dispensing quantities in the contract, and that the contract must contain regulations on what happens in the event of a deviation from these quantities. That's something Stefan also mentioned in his slides up front. The pharmaceutical company must upfront provide the GKV, upfront the negotiations with the estimated the estimated quantities and packages he thinks he's going to sell to the GKV in the following years, in addition to the information on the European prices and information on comparative drugs. So the company must inform the GKV of its expected annual sales, usually broken down by package and by milligram active substance. And these expected quantities and annual sales volumes of the drug then become subject to negotiation, because in the contract you have, most of the time rules in there that there are some legal consequences are attached to any deviation, usually only in excess of those quantities, such as a special right of termination of the contract for the GKV. Of course, there have to be rules in the contract how to handle claims for subsequent reimbursement, meaning in this case, if the contract is concluded after it's the new reimbursement amount takes place, or the pharmaceutical company does not report the new price in the Lauertax until after this date. And the handlers of this subsequent reimbursement claims, of course, in conjunction with then the no longer appropriate manufacturer discounts and wholesaler surcharges and so on, must be regulated in the contract. Of course, there are also reporting duties, for example, to the IFA for the listing of the new price, and also to the GKV in case of new launches or transfers of the drug to other pharmaceutical companies. Everything must also be regulated in the contract. Of course, there are also confidentiality rules, and in case you have a drug with an added benefit, you may negotiate with the GKV a kind of practice speciality. And the German word is Praxisbesonderheit. It's nothing you can really translate correctly, I think. Practice specialty means that the drug is then privileged if the doctor prescribes this to the patient, and the doctor does not have to fear any consequences afterwards by the GKV. Of course, there may be other contractual provisions, for example, kind of annual treatment cost guarantee in case of future changes to the dosing in the SMPC. That's everything you have to talk about with the GKV and to negotiate in this reimbursement agreement. Of course, it's a great importance of determining the reference value. You always have to keep in mind the life cycle of the drug. And if you have any extension effect of reimbursement amounts for new packages. So it's something you also have to keep in mind. Next, please. If you have to, or if you could agree with the GKV on a practice specialty, of course, there may be or should be other contractual regulations. The law says that the reimbursement amount agreement should also include requirements regarding the appropriateness, the quality, and the economic efficiency of prescription. For example, the agreement on start and stop criteria for the therapy, notes on cost effectiveness, definition of a therapy path, information to all the Association of Statutory Health Insurance Physicians, health insurers, and audit panels, agreement maybe on mutual communications to doctors to ensure the compliance with the agreed upon area of operations, and so on. Next, please. Of course, the GKV, as in any negotiation, I think, is not always happy with the wishes or suggestions of the pharmaceutical company. So, of course, you can reject or you can confront then and say then that there's a negotiation autonomy, that you can agree upon anything if it's not against the law. You can reference to the wide scope of the negotiations, which I already mentioned in paragraph 130b, paragraph 4. Of course, tell them the legal reasoning as to why the idea is permissible, reference to former arbitration board decisions and or case law, and of course, refer to the objectives of the AMNOG, which wants to improve only the economic efficiency without affecting the scope of services for the patients. Next, please. Of course, there's a legal defense if you're not happy with the outcome of the negotiations. If the parties do not agree upon a reimbursement amount agreement at the end of the negotiation dates and at the end of the negotiation period of 6 months, there is the possibility to call the arbitration board, and or not the possibility, it's a duty to call the arbitration board, which has to decide within 3 months. If the pharmaceutical company or the GKV is still not happy with this decision, it may appeal against the arbitration board decision with a social court action, first to the Regional Social Court of Berlin-Brandenburg, and then further appeal to the Federal Social Court of Justice. Next, please. The Federal Social Court of Justice has made, after 10 years of AMNOG, finally a couple of or a handful of decisions on those AMNOG cases. So it's arriving more and more in the jurisdiction. The level of the control of the arbitration board decisions is not very deep, because the Federal Social Court says the decisions are not often not based on facts that are accessible to evidence and are judicially qualified as correct or incorrect. Rather, it's a matter of the prognosis, assessment, and evaluations of the body staffed with experts. The expertly staffed arbitration board is a guarantor for decisions that are justifiable, and the review by the Federal Social Court is only with regard to the laws of logic, and of course the principle of general life experience, and of course as everything is in accordance with the law. Next, please. It is also advisable, if you seek an appeal against the arbitration board decision, to keep in mind if you want to appeal against the GBA benefit, early benefit decision as well, because the GBA decision has a kind of is like a law for the arbitration board and also for the courts. So if you want to file objections to the GBA decisions, you have to seek a declaratory decision on this legality of the GBA decision. The pharmaceutical company has all in all an increased burden of proof in the whole process, especially in the dossier. So you have to be very careful what you put in there. Better put more in the dossier than less, so that you have at the end all the possibilities in a court procedure. Next, please. Yeah, and finally, I'm at the end. The law and the framework agreement set a general framework for the reimbursement amount negotiations and the contract. The reimbursement amount is strongly influenced by the element of negotiation, especially for drugs with an additional benefit. And more and more, the reimbursement amount is arriving in the jurisdiction. And of course, you have to be very careful, although the contract is quite short, what you negotiate in there. Thank you very much.
Perfect. Thank you very much, Bibiane. I think it shows also, I think, the importance not only to let's say also prepare, but I think also to have the kind of right person like a lawyer quite clearly in the negotiation team, because I think it's not only that you need to come up with a contract, but it's a lot of different kind of aspects and a lot of as well legal decisions in the meantime, which is also important keeping in mind. I think ultimately, I think just a very brief kind of conclusion before I will hand over to Lutz. I think well-prepared negotiations can be a driver to be successful quite clearly. You see that as well with the, we just said price impact foreseeable. I would still not say that this is really foreseeable, but I think if you're well-prepared, you can be successful. And that basically includes not only, let's say, the kind of preparation in terms of you know, how the frame looks like, how you would need to go in there with the different kind of tactics, but it's also obviously having in mind all of the different kind of drivers, all of the different kind of aspects which might be coming into the negotiation. I think very important, Bibiane, what you also said at the very end, I think a lot is driven by simply negotiation, right? So this is this kind of, you know, back and forth and fighting and finally still coming to an agreement, which could be fun, which is again coming back to the Bruce Willis, but a lot of times it's just really hard work as well. So
yeah, definitely, and always be prepared, and a good preparation is everything, I would say, in these negotiations. Yeah. And it's, for me, I'm only a lawyer. I mean, I'm not handling the numbers there, but it's, I think, not foreseeable, and it's a, yeah, you have to watch the big glass ball to see what's the outcome is. So there are so many factors you have to keep in mind.
That's true. Very good. Perfect. Thank you very much, Lutz.
Wonderful. Thank you both. That was really a great presentation of both of you, really detailed, and we have plenty of questions actually. So actually you answered the first one. So one question was, do I really need preparation? Yes. So preparation is all and everything. So if you don't go, if you go there unprepared, right, they're like they're not even like Bruce Willis. They're like more like the
no, then you're thrown to the wolves. Don't do it.
Exactly. I would have said sharks, but I like the wolves as well. Yeah. You can choose if it's sharks or the wolves.
Okay. So let us start with some more general questions, and then we have also some details questions. So the first questions, which is asked, is actually a good one. So what is the negotiation language? Could it be also a negotiation in English, or is it German?
The framework agreement says that the negotiation language is German, but we've also done together negotiations with an interpreter. It is possible, and what I can say from my experience, I've also done arbitration board procedures with interpreters in English. The GKV negotiators are quite good in the English language, so they are open to this too. But that's what I would always recommend. Also from my experience, it's always good to negotiate in German. It's if you have an interpreter with you, of course there are breaks, and there are it's a fracture in the whole negotiation flow you have. So yeah, I would recommend do it with a German team. It is possible otherwise, but it's not ideal.
Okay, great. And then who should be part of the negotiation team?
I would always recommend that at least one person of the negotiation team should be from the company itself, of course. I mean, we've done negotiations only with external people who are not with the company, but one should be with the company. You should at least have one from the medicine field there, and someone from market access too, who knows to deal with the quantities, with the sales and the European prices and is familiar with that. And last but not least, I always recommend to take a lawyer with you, someone who's familiar with the law, because not only the contract, but you have so many other legal questions in these negotiations, which you cannot foresee. So it's always advisable to have those with you.
No, I would agree. I think I would maybe just add, I think what I normally as well recommend is to have an observer as well.
Yes,
who is just obviously not only observing how the own team is obviously doing, but especially obviously observing how the other side is reacting, how they are dealing with different kind of things. I mean, when you're in the middle of the whole kind of discussions, I think you cannot really follow that closely, how the other side is really reacting to it. So I would just add that one. I know you're as well a big fan of an observer.
Yeah, absolutely. I mean, you have to keep in mind there are only 5 people in the negotiation team. So you have to pick very carefully and
Great.
You're
and
right.
Then we have another question. What is the best point to start preparing the negotiation? So when would
rather
you
sooner
start?
than later, I would at least say, right? No,
Yeah.
but I mean, at the end of the day, I think it also depends a bit on the process, right? I mean, you have seen the AMNOG process. I think the first part is the added benefit, but I think what we normally do is that we start at least very broadly shortly after the oral hearing, because before you obviously need to prepare for the oral hearing, all of the written statements, etc. But I think that's normally the time when we start with that, which is, let's say, roughly would start 2.5 to 3 months before the first negotiation day, which is still, let's say, the kind of easy, I would say, the easiest part of the whole negotiation, right? But I think that's I would say the optimal part, I personally think, to start then in detail. Obviously, a lot of times you need as well to think ready beforehand, because your launch price, which is due on the first day of your let's say time on the market, right, is obviously your starting point in the negotiations as well. So you need as well to think a bit further beforehand what should be your launch price, because that's your starting point in the negotiation, and what is then your kind of target price after the negotiation. So this is also the answer, or let's say the important information you would need to have ready, obviously, quite some weeks and maybe even months before you launch the product in Germany. I don't know what you, Bibiane, think about it.
Yeah, in my ideal world, I mean, you start creating your strategy way before during the clinical trials. And but this is an ideal world you don't have very often, because you have always these big companies, worldwide companies, who are not so, cannot move this in this way. But as you say, you have to prepare a couple of months beforehand, and you always have to keep in mind that the GKV negotiators are negotiating 24/7, and they are very experienced. And it doesn't hurt if you get a negotiation training up front and to really get a deep and good preparation on all the topics that arise: the European prices, the sales, the prices of some comparators, the comparable drugs, and everything. And as we know, when we work together, Stefan, it's something we really, what the companies need if they want to succeed in these negotiations. So
great. There's a question: can I speed up the timelines for the negotiations? Does it make sense?
Yeah, I mean, it's something, as Stefan said, I'm always asked, what are we doing? 4 times 4 hours of negotiation, 16 hours? It's so long. It's not. I mean, because you have so much to talk about, and 4 hours go by in a blink of an eye. So it's nothing you can speed up. I've seen negotiations and in the second negotiation date, but these are, I think, it's not the rule. It's the It's not the rule.
Okay.
You really need those 4 dates, and they cannot be changed, those 4 dates. If you don't go to a negotiation date or cannot do because you have other the date is not right for you, then you have to have, you know, a 5th negotiation if the GKV agrees upon this.
Mm.
So it's nothing you can speed up. The whole process is in the framework agreement, and we're in Germany and we follow rules.
Exactly.
Yeah, that's really nice. So, and also you can actually have additional documents, right? So that there's one question: what evidence submitted, or better, what additional evidence submitted can support the price negotiation? So you can, in the price negotiation, I mean, we can also add later some additional evidence, right?
Yes, in the AMNOG process, it's quite regulated. The Diga process is much more open, and I think they've learned from the AMNOG process. But the AMNOG process, the evidence and the information you have to hand in is limited, and all is written down in the framework agreement. Of course, that's what we advise always the companies. You can hand in more or bring more everything, which helps your strategy and your story, of course. But the negotiation is based on this information which the framework agreement requires, meaning the decision, of course, of the GBA, the European prices in case of a drug with an additional benefit, the comparators, and the comparable drugs, and of course the sales, so the quantities.
Okay. What's the main difference between the Diga price negotiations and the AMNOG price negotiations for the digital and the drugs?
There are a couple of differences, and I mean we haven't had so many Diga negotiations. I mean they just started, so there are not so many dates. You can discuss upfront with the GKV whether the date suits you or not in the Diga process, which is not possible in the AMNOG process. And of course, there are a lot of more of information required and possible to hand in the Diga process. Maybe it's a good topic for our next webinar.
Yeah,
I agree.
when we have some more experience, right?
Yeah.
Okay, out of the Diga, so they just started and they're just in the first process. Okay, now let's dive deeper into the AMNOG price negotiation. So about the practice specialty, the Praxisbesonderheit. Is the practice specialty always negotiated by the GKV, or can they refuse negotiations about that?
The law says that for drugs with an additional benefit, practice specialty should be negotiated. Should. It doesn't mean it has to be negotiated, it should be negotiated. Which means, of course, it should not be the rule in any case. The GKV, from my experience, is always very reluctant to negotiate. It's a practice specialty, which you can obviously see if you compare the number of the drugs who got an additional benefit by the GBA and compare it with the drugs who haven't practiced specialty. You can see those drugs on the homepage of the GKV SV in the internet. They are all the all the drugs are listed there who are negotiated, and then you can click and say you only want to see the drugs with a practice specialty, and the number, you know, differ. So there are much more drugs who have an additional benefit than drugs who have been negotiated a practice specialty.
Great. So and then there's another question about the contract duration. Why is that so important, and what is actually the normally expected duration which is accepted by the GKVSB?
So the law says that this reimbursement agreement should at least have a duration of 1 year. And of course, to have security in your planning, it's always good to have a contract which has a longer term. But I think the term is not that important, because it doesn't mean that the contract is terminated after this duration. You know, it's only the minimum duration you agree upon. So the minimum duration is 1 year. Of course, it's good for the company, and I mean, depends, of course, on the case, in the individual case. But of course, it's nice to have a longer minimum duration. From my experience, 1 year is always good. I mean, that's what the law says. But of course, there are 2 or 3 year contracts. But again, these are not the rule. The most contracts have a minimum duration of 1 year, maybe 2 years.
Mm-hmm. Great. And then we have that situation when we don't come to an agreement, and then we have the arbitration board. And Nicholas is asking, how frequently is the arbitration board getting involved, like in percentage? And actually, Nicholas, you also want to watch our recent webinar with Professor Dr. Walzer, where we have a closer look on that. But do we have a number on that?
I don't have a specific number, Stefan. Do you?
Yeah, I mean,
as you don't even know it.
Yeah, exactly. I mean, I think it's also the kind of question, you know, the definition of the involvement, right? A lot of cases are opened, but then you still, or let's say, already come to an agreement before you even get into the real arbitration, right? So that's, I think, one thing to consider. I think overall, I mean, I don't have the number in mind, but I mean, we have it on the files, but I think the trend, I think, is quite clear. At least I think in the last year, right? It's going at least further down in terms of arbitrations than finally decided. I think that's maybe the right kind of terminology probably to use.
Yes, definitely.
And then after the arbitration board, we come into court, right? And one question is asking, who was the winner in the recent jurisdictions? But as we know, I mean, with the lawyers and going in front of the court, are there really a winner? Is the company or the state health insurance is the winner, or is it just a lose-lose situation?
I mean, are there winners or losers? I mean, it depends on which side you are standing. The recent decision of the Federal Social Court on dimitro fumarat, I would say, of course, the pharmaceutical company has not won. I mean, that's something you can say. And I think, but what I think the whole process has lost, the whole AMNOG process. Because, I mean, we don't have the written reasons yet from this decision. So it's something we have to look into before we can, tell what the what this decision will do with the AMNOG process. But I think it has made severe damage to the negotiation process for drugs without an additional benefit, because now the other party, the GKV, might be tended always to take the cheapest drug as the comparator costs. And in my opinion, this cannot be the case, because the cheapest is not always the most economical drug. But let's say what the Federal Social Court says in its ruling.
Okay, and there's a question related to that. How often are further drugs used as a reference drugs in addition to the appropriate comparator therapy drugs? So, you know, the GKV comes up with another drug, right? And do they have to be approved in this indication?
That's something on the one hand, the Federal Social Court and also the Regional Social Court of Berlin-Brandenburg, I think, answers, if I got the question right. Of course, if you have a drug with an active substance which has not been on the market in the at the time where the GBA decision was made, it is okay if the active substance is mentioned in the GBA decision as a comparative therapy.
Great. Yeah, that's actually, we have some more questions about the future of the AMNOG or GBA. So we covered also that in the last webinars, and also with a few to the changes to the orphan privilege in 2022. So there will be some changes, but we will cover also that after the elections. So thank you, Bibiane, for that wonderful presentation tonight and answering all that questions. And also, Stefan, thank you also to you. Once again, if you really like that webinar and you did not catch all, you can rewatch it on our website, www.marketaccess-pricingstrategy.de. And then we have a really special present for you, which is 5 more days. And then actually you can listen to us on our map, on our Market Access podcast, the first and only Market Access podcast by Mars. And you can find us everywhere on the podcasts, web pages there, and with our good friend Dr. Jan Helfrich with a speaker. And then I think later we also have Bibiane then there in our podcast. So you don't want to miss that one. Great. So, oh yeah, thank you all for your all the audience for your feedback tonight. That's really wonderful. Thank you for that. And then thank you all again to your speakers. And we don't want to miss our next webinars. Once again, Dr. Thorsten Peske about Austria, and then with Dr. Matthias Perlet from the Federal Joint Committee about the experimental coverage in Germany, and then with our good friend Dr. Matthias Brunel from the KV Westphalian Lippe about the regional drug budgets, not projects, regional drug projects in November. Great. So thank you all. Thank you, Bibiane. Thank you, Stefan. Thank you.
Thank you.
Have a good time.
Thank you, Bibiane. Thank you, everybody. Have a good evening.
Bye-bye.
Bye.
Thank you. Have a good evening. Bye.
Bye.